Good morning again, everyone, and welcome to Top Tips for Year-End Immigration Planning, an NJBIA HR program brought to you by Association Member Trust, Connell Foley, Investors Bank, New Jersey Business Magazine, New Jersey Manufacturers Insurance Group, NJBIA HR Support Center, and PrimePoint HRMS and Payroll. I'm Alice Gens, and I'm the Chief Operating Officer and CFO with NJBIA, and with us today are Neil Dornbaum, Victoria Donahue, and Kathleen Paraguay of Connell Foley. Before we begin, we'd like to show you a brief video on the NJBIA HR Support Center, which has some great resources for all our member businesses.
Your business pulls you in a lot of different directions. Managing HR is just one of them. What if you had a team to turn to that could take the guesswork out of HR, save you time by researching the answers for you, and help protect your business? Don't worry, we've got this. With the all-new HR Support Center, we offer in-depth advice and insights you can't find anywhere else. Plus, with HR On Demand, get live unlimited consulting with our team of certified HR pros, HR experts who are easy to talk to and are ready to help. Get ready to experience HR in an entirely new way with the HR Support Center and HR On Demand.
Okay, today's presentation is being recorded and will be emailed to you later this week along with PowerPoint, so be on the lookout for those. I'd also like to draw your attention to the chat box. Victoria, Neil, and Karen would be happy to take your questions, so get them in as they come to you. After today's presentation, we'll have about 15 minutes to network with our speakers. And now it's my pleasure to introduce our speakers from Connell Foley. Neil Dornbaum is co-chair of Connell Foley's Corporate Immigration and Global Mobility Practice and is recognized as one of the most active and distinguished immigration attorneys in New Jersey. Neil has dedicated his practice for over 30 years to immigration and nationality matters with a special emphasis on employment-based immigration. Neil has served on the editorial board of several publications, including New Jersey Lawyer and Kussbaum Immigration Law Sourcebook, and has edited over 40 course books on immigration and nationality matters and chaired over 50 immigration conferences. Kathleen Paraguay is a highly accomplished immigration attorney and serves as co-chair of Connell Foley's Corporate Immigration and Global Mobility Practice. Kathleen has focused her practice for the last 28 years on immigration and nationality matters, particularly strategic employment-based immigration matters and international transfers associated with complex merging, acquisitions, and reorganization of businesses in the pharmaceutical, engineering, and financial services industry for universities, for high-level researchers, and other of extraordinary ability. She's been particularly successful in global mobility matters during COVID-19 pandemic, despite presidential proclamations banning international travel and obtaining national interest exemptions for key personnel. She lectures extensively on advanced immigration law topics. Victoria Donahue has an extensive background in immigration law for over 20 years experience advising clients on the full range of issues related to employment-based immigration and non-immigrant visas. Her experience includes handling complex requests for evidence, RFE, issued from the U.S. Citizenship and Immigration Services, USCIS, advising employers on I-9 and labor condition audits, USCIS denials, and client representation in immigration waivers. Prior to joining Connell Foley, Victoria served as an Associate Director of Human Resources, Immigration, Labor, and Employment Relations at the Research Foundation of the City University of New York, a 5,000 employee nonprofit corporation. Well, you've got a great group of speakers this morning. Thanks so much. And now it is my pleasure to turn it over to Neil.
Thank you very much. Could we advance the slides 2, please? Next one. Excellent. Well, good morning, everyone, and thank you very much for joining us today. This is that time of year where most of us are looking to get together with family and friends and doing that last-minute shopping. But Unfortunately, if you are an HR representative, this is probably your busiest season. We are now at that stage where you need to do your year-end planning, and we are going to talk to you a little bit about some of the things that should be on that checklist as you go into the end of this last quarter, particularly if you are lucky enough to represent foreign nationals on your staff. The first one certainly always deals with the fact that we are at compensation and review period, and that is probably the most stressful period of time for HR representatives. It is also a stressful time for our foreign nationals because with immigration, you need to be aware that foreign nationals can be impacted negatively by changes in job duties, changes in title, changes in their compensation, and changes in the location of their employment. So it is really critical that you are working with your compensation department and your managers at this point in time to identify those individuals who are foreign nationals on your workforce. And if you are in fact considering changes to the duties and title, it's not that that can't be done, but it may require an amended application to also be filed to support their status here in the United States. And that's really critical because over the last 2 years, things have been very, very slow with regard to the government, but now they're beginning to pick up again. And one of the big ones is FDNS, which is the agency that comes out unannounced and does spot inspections for individuals that are currently working in the United States as a foreign national. And that impacts individuals who are here in your F1 student status, H-1Bs, H-2Bs, and your L-1 intercompany transfers. So it is critical that if in fact an FDNS, a fraud detection and national security officer comes out, they want to verify that the individual is in fact working in the job title, performing the duties that have been set forth in the underlying application, and that they are working at the location where they are supposed to be working at. And remember, work from home does require, in most instances, particularly for your H-1B workforce, that the individual has an approval notice for that location. And also remember that any changes in the duties, title, compensation, and location have to be done and amended prior to the action occurring. So you can't move them to a new location and then file the amended application. That would be a violation. So that's number one on our list. Number two is staffing. And at this point in time, most companies are beginning to look towards the new year and trying to figure out what your staffing needs are going to be. So one of the main things that we're going to be discussing today is how do you in fact staff up? And predominantly, how do you deal with caps and quotas and the timing that's going to be necessary for you to plan with your appropriate management teams, hiring of individuals that are going to fill key roles or highly skilled positions. The third area that we're going to talk about today is your travel concerns. At the end of the year, we have individuals who, for the better part of the last 2 years because of COVID, have not had an opportunity to travel outside of the United States to see family, friends, or to conduct business. Well, the State Department is picking up again, and individuals are traveling more than ever if you've been to any of the U.S. airports. But the big problem still is U.S. consular operations overseas are not fully staffed up at this point. And this is always a busy season just because of the holidays, but it is even more so a problem right now because most consular operations have not come back to full operations. So you need to be planning appropriately for employees who are going to be traveling outside of the United States. Make sure that they have the proper documents upon leaving, that they have the proper documents to present. And if they don't have a visa and require a visa to come back into the United States, you have to plan accordingly that they may be stuck in administrative processing, which could delay their ability to come back into the United States, or their inability to even get a consular interview at this point in time, though we're also going to talk about some of the waivers that are available. The other area that you need to discuss, and we're going to touch upon today, is retention of those individuals who currently work for you. There are two basic areas that we need to address. One is individuals who have non-immigrant status or a work authorization that will expire so that you're planning accordingly and getting enough time to file those applications. And number two, are those individuals who you wish to retain on your premises.
Unknown
because-
caller.
So, those individuals you wish to retain, because you have to be pre-planning based on how long it takes to process someone for permanent residence, and you don't want their temporary work authorization to expire. Some of the other areas is if you are involved with a potential corporate reorganization, merger, acquisition, or a creation of a new office, there is pre-planning that goes in. Not only do you need to make sure that the I-9s are being checked as part of any acquisition, you also have to look at the status of any foreign nationals to see whether or not they will qualify as a successor in interest, or whether amended applications need to be filed, because that could impact the date of the reorganization or merger taking place based on the critical nature of the individual. Also, maintenance of status. Again, you do need to be planning ahead of how many individuals you have who have statuses expiring, and you should be working closely with your I-9 group in conjunction with that. And that brings us to the last one that we're going to talk about, some of the cases that have been coming down in the compliance end. You certainly should be doing your year-end I-9 audit, and there should be additional training based on a lot of the recent cases that have come down dealing with potential discrimination. So that's where we have a full agenda today. So we're looking forward to doing that. The one thing I would say is if we could slip to the next slide. You just need to be aware that the consequences of non-compliance in the immigration field are fairly significant. They go from hiring delays and rescheduling of start dates if you have not planned accordingly to bring in the staff that you require and that you don't do the immigration pre-planning up front. There could be delays in your own contracts, your product launches, and some of your other essential business operations. If you do it wrong and the person falls out of status, it could result not only in their termination and dismissal, but it could result in their actual removal from the United States. You obviously are going to have some disruption of business travel if you're not thinking ahead as to some of the indications that the person might run into a potential problem going outside of the United States. We have federal government audits, which we're going to talk about, restrictions that could be placed on your company on the future hiring of foreign nationals. We're seeing a lot of action in the discrimination area against employers from IER. And lastly, if you do get it wrong, you potentially could face a violation, both not only a civil fine, but also potential criminal penalties for the employer. So with that, let me turn our attention over to Kathleen to talk a little bit about some of the changes in duties, title, compensation that you should be aware of from the HR standpoint. So if we could slide to the next slide. And let me turn the program over to Kathleen.
Okay, thank you, Neil. I think that picking up from what Neil was saying is a key component to remember in your process as HR. A foreign national employee is the same as a U.S. citizen employee in terms of all the things you do for HR, with one really important exception, and that is compliance. If a foreign national employer is there on your site, they're there by virtue of a government approval that allows them to perform certain duties for a certain period of time. And the purpose of a lot of the compliance aspects is to provide notice to U.S. workers, because the goal of the immigration requirements and regulations are that by employing a foreign national worker, you're not adversely impacting the wages and working conditions of your U.S. workforce. So what you have to be aware of is when you have someone who comes on board, they're there to do a particular job that's been pre-approved by the government. If you're going to make any change whatsoever in what they're doing, you have to first take a pause for a beat and just think before making the change, what kind of an approval do I have? What is the present state and what is the individual approved to do right now? If I make any change in their terms and conditions of work, is there any change in that present state on which the application was based? So if they came in a certain job title to perform certain job duties, if there's a promotion, is that going to change anything in terms of what they were originally approved for? If so, that may impact the approval that you already have, and you may have to get a pre-approval from the government. Now, that sort of instills consternation. You don't have to worry that you have to make that decision on your own. It's really an issue spotting thing. If you know you're going to change someone in any way, shape, or form in the job duties or the location, then what you want to do is just have a flag go up and to say, let me just run that past Immigration Counsel to make sure that everything is still in compliance. In many cases, a person may be a programmer analyst, for example. They started as a programmer 1 and they're going to be a programmer 2. There's no real material change there, so there's no real need to change the approval notice or to get any other further approval or amendment. So then you may be all right. But if all of a sudden the person sets the world on fire and you want to make them a technical lead or a manager, a director, that may change the approval that you originally had for them. So a red flag should just go up to say not no, but yes, but what, if anything, do I need to do beforehand to make this happen? So pre-planning, which was what Neil was talking about, is key. If there is going to be some kind of a change, you want to, and you need an approval, you want to also consider what timing is going to be required to get the approval. In many cases, you're not able to make the change and then get the approval. You may need to get the approval beforehand. The other question is a really important one. Does the individual, by virtue of their employment history and their education, qualify for the new position, for the new approval? And if an amendment or any change is needed, is the employer willing to pay the cost of that? So very often a manager will come in and say, want to promote so-and-so, HR, get it done, without a whole lot of thought about how that's going to happen. So for HR to be the wise conscience of your managers, to consider, have we looked at everything first? Are we in line to do this with government approval so that we don't run afoul of delays in the promotion or violations in the event that we were supposed to have done an amendment and didn't see to do it? So a couple of points for when an amendment would be required. The example of the programmer analyst 1 to 2, no amendment really. But other things that may require an amended or a new approval are a change of the employee's duties from one specialty occupation to another. So again, that programmer analyst who then becomes a director, a VP, a lead, a manager, that has a different coding for the government. So that may require a change or an amendment. Also, a reduction in the number of hours. We're seeing that the economy's been soft. Employers have been trying to hire and hiring up, but now they're looking at some danger zones in the economy and thinking maybe we need to reduce our workforce a little. If we're reducing the number of hours worked per week, you have to be careful with, particularly with H1 holders, because you've agreed again with the government on your approval to employ the person at a certain wage for a certain number of hours. So that if there's any change, it may mean that you need to do an amendment to notify the government, and you're not able to reduce their wage below what you've already agreed to pay. Similarly with reduction in salaries or wages. If you do have a plan where you're going to reduce wages across the board, there have been waves in the economy in the past where companies have been asked to impose a 20% reduction and things like that. That is another case where you may have to do an amendment. Another issue is a substantial increase in salary or wage. This would be a promotion. So if we have a situation where someone is going to be that VP, director, manager, great news. But if there's going to be a change, increase in the salary, it may mean that you're going to have to do an amendment to get government approval for that. And that's where it comes in to make sure that the individual, by virtue of education and experience, is qualified for that higher level. The other thing you have to worry about is if you change a job, the government requires prevailing wage determination. So you may be giving them a big increase, but the government may feel that a manager is getting 200,000 plus, which is more than this person's own manager is making. Does that, for pay equity purposes, work within your structure? The last one that might require an amendment would be a change in location of employer. So let's say you merge, you reorganize, or you just rent another space. If you're going to be moving from one town to another, It may, in the same metropolitan statistical area, you may only have to post. But if you are outside of a metropolitan statistical area, you may need to actually amend. So remember that the person who catches you on these things, if you don't, is the FDNS. That's the federal government performs site inspections. So they have the paperwork that you've signed, and they could come unannounced on your site and ask to see so-and-so and so-and-so's manager who signed the paperwork, and then to determine whether or not that person is on site performing that work. This sometimes runs into problems when you have a lot of contractors on the site, where an auditor will come on and ask you pointed questions about what kind of work this contractor is doing, or your employer. So once again, pre-planning is key. It's not no, it's yes, but have we checked everything that we need to check in order to make sure we can do this without an amendment or some kind of a pre-plan? So Neil, if you could advance the next slide, we'll just talk about common situations where you might see this. Key leaders, highly skilled technical workers, they're very often H-1Bs. You're often in this mode when you're looking at promotion or upward mobility. You're looking at situations where you as HR may not even know the immigration status. We don't walk around with arm badges, or sometimes our immigration systems don't even tell us what status someone is in. So again, you should add to the due diligence process anytime you're going to do a promotion to look at immigration status, just to find out, and you can do this without in a non-discriminatory way. You would have done an I-9 for the people that are coming in, and Neil will talk about I-9s later. But for the I-9s, you'll be able to tell by the attachments to the document what the status is. So again, part of pre-planning, check status before you're going to go ahead and do that in terms of making any changes. And if we can advance to the next slide, we want to talk about H-1B. Again, the H-1B is usually your most fertile source for foreign workers. Many come to the U.S. as students. They graduate. They're given 1 year of optional practical training, which is work authorization. If they're STEM, they're given an additional 2 years, so they get 3 years after school. But because the H-1B is a lottery system, you have to get into the lottery you have to be in it to win it, as they say, in order to change your status after the F1. It's 1 year, STEM adds 2 years, that's 3 years. But after that, unless you have gotten another status, meaning change to H1, you have no work authorization and no other avenue to get it. So the H lottery is starting, gathering the information is really now. If you want to look at your workforce and you want to take a look and see who you might have among you who is hired as an F1, an OPT, a STEM OPT, who needs work authorization to continue, you want to get in line to do that lottery. We're looking at the great outside of your employment also. The great resignation is triggered by COVID-19, and there's a lot of remote work. There's a real shortage of qualified applicants. So searching for great candidates really has to be a broad net that you have. And you have to remember that you can hire an H-1B even if you're not a global company, even if you don't have international offices. You can be solely US and still hire an H-1B worker. The cost of this is pretty manageable, and the timeline is very reasonable. The worker who you hire is authorized to work initially for 3 years with an extension, an additional 3 for up to 6 years. Some of these workers might be already working for you at another status. So there may be someone who came as a TN or a spouse of another worker who has separate work authorization, and they can be converted. So you'll often see people in EAD, spousal H-4s, who are able to convert to this H status. You don't have to advertise, but you do have to pre-plan, because there are 2 types of H-1B workers. Those in another status who are filing for the first time, they're CAP workers, and that's a lottery system. And then those that are already in H-1 status for another employer who would just need a change of employer. In your analysis of this and your pre-planning, you want to remember that 6 seems to be the rule to remember. An H-1B can work for an H-1B employer in status for up to 6 years. That's the first 6. While the HCAP cases can be available, if you hit the lottery of the HCAP, they can start work in 6 months. The H transfer cases, those that are already in H status for another employer, can start work with you as early as 6 weeks. And a successful H1 would result, assuming that you pre-plan, in a long-term relationship with a degreed professional employee who can be onboarded within a reasonable time frame. So again, when you're looking for workers, if you're not in a layoff mode or a reorganization mode, the H-1B worker is really a good bet, a good place to look. So in terms of the H-1 cap, though, again, in that pre-planning, you have to think in terms of the onboarding. Right now, we want you to start looking at your current workforce or other candidates you're looking to hire, and let us know by February 15th whether or not you'd like to join the lottery for the H. March 1 through March 18th, you can register for that H-1B lottery. If you're selected in the lottery, now you have the opportunity to file your application. The application will be filed April 1 through June 30. And if you're selected, then October 1, 2023. Okay, we're looking, sorry, the slide says 2022. So you're looking at 2023, and October of 2023 is the effective date where you can start to work on that H-1B. Even perfect filings, though, don't guarantee H issuance because it is a lottery. You may have to look in terms of filing more than once. That's why if someone comes to you as an F1 on OPT, you may think, I've got 3 years, 1 year of OPT, 1 year of STEM, or I'm sorry, 2 years of STEM OPT, and I can wait a couple of years to file the H. With a 40% approval rate on this lottery, you may have to file sequentially. So that's why it's so important to look at who you might have who's an F1 student that already on staff, or somebody you're looking to hire, and then assess whether or not you're going to be willing to go through this process and pay the cost and wait the time required in order to bring that person on. So I'm sorry, Neil, if you could just advance that next slide, or that next slide, and then I'll give those dates again. And remember, everyone, we're talking about 2023 registration, March 1 through 18, April 1 through June 30, 2023, and October 1, 2023, the effective date for bringing these people on. Now, next slide is how we look at those key dates again. If someone is at an F1, you're looking at people who have been here in the United States for quite some time. F1s, they attend school and graduate. They start work on the F1 OPT for 12 months. They go on STEM extension if they're science, technology, engineering, or math, get 2 more years. And the H-1B, continuing working for 6 years. Now, someone's going to be pretty loyal to you if you're willing to hire and process for the H-1. And that is going to be, a good long-term solution for you. Okay. Now, with that, I'm going to turn over to Victoria, and we're going to talk a little bit about premium processing rules. Premium processing may or may not affect the H-1 situation. It's probably separate from the cap. So it's another thing that you will want to consider as you're going forward. Victoria, do you want to then segue into premium processing rules?
Sure. If we could just advance to the premium processing slide. There we go. Okay, so premium processing provides expedited processing for I-129s and for some I-140s. So what's new about this, well, let me backtrack. what it provides is that for a fee, which generally is $2,500, you're guaranteed some adjudicative action by USCIS within 15 days. And some adjudicative action can be as little as issuing an RFE. It means that they have to do something within 15 days. So what is new is that recently they have expanded this to include two types of I-140s that were not previously included in the program. One of them is multinational executive and managerial positions, and the other is national interest waiver petitions. So, but these are a slight bit different because it's not 15 days, but 45 days. So they have 45 days, again, to take some adjudicative action, however small that may be. And those are also $2,500. Should they miss their deadline, so in other words, they don't take any action until, say, 55 days, then you as the petitioner get the $2,500 refunded. That's sort of the remedy that you have, although you won't really have premium processing, so it's of somewhat limited value.
Victoria, can I ask a question on the premium processing for expediting the Form I-129 on the H's that I was just talking about? That might help employers to bring someone on faster. Would that be right, if they are already in the H-1 status? So it's another factor an employer could take a look at. There's an additional fee, but that may be something to get someone even faster than the 6 weeks. Is that right?
That's correct, assuming that they're already in H-1B status. Okay, if they're not, then the normal October 1st is going to be the start date, regardless of whether you use premium processing.
Okay, thank you.
Yeah. Okay, if I could have the next slide. Okay, so I'm going to speak about travel restrictions and requirements. So one of the things I'm going to talk about is the vaccine requirement, which is relatively straightforward. And that's basically that you can't, unless you're fully vaccinated, you cannot board a flight. Now, there are a few exceptions to this, and they're set forth on the CDC's website. But just to give you an example of a couple so that you have a flavor for what might permit you to travel without vaccination. One is for people who are doing diplomatic work. Another is for individuals under 18. And another example would be if you have some sort of documented medical issue that prevents you from getting the vaccine. And there are others, but that's just to give you a flavor of what are possible ways to not have to meet the vaccine requirement. Okay, so next thing I'm going to talk about is a little more complicated and has been more vexing than the vaccine, and that's actually we went ahead, I think. That's it. That's the consular operations update. So basically, there are tremendous backlogs for consular processing due to the COVID-19 pandemic. When the pandemic first started back in March 2020, consular operations were completely shut down. So that created an enormous backlog because there were no appointments for quite some period of time. And then, so they started again, and some consular posts are doing better than others. So in some places, things are getting back to normal. In other places, they are, but more slowly. So what the Department of State has done that's helpful is that they have hired more foreign service personnel, and that's it's shortening the wait times because it's permitting the personnel are able to get through the caseload faster. So that's a plus. And the Department of State now says that it expects pre-pandemic processing levels to return this year, and that so for non-immigrant visas, they say they're at 94% of the pre-pandemic monthly averages. And for immigrant visas or green cards, they're at 130% of the pre-pandemic average. So they're actually doing better. So there is progress.
Victoria, can I ask a question there for HR? Thinking about this, we're thinking visa processing. It seems to me that the two areas that would come that would affect the business most are personal travel. If someone is, let's say, an H-1 worker and they want to go home for Christmas, but they don't have a visa to return to the United States, they might have an issue in terms of how long will they be away from their job. They may not be able to get an appointment. The other I thought was on business travel. Maybe we could take the two of them separately. For business travel, if we have someone who's an international transfer who wants to come into the United States, he or she may be delayed precipitously in being able to come in and assume because of these travel restrictions. For a personal travel, could you just describe really briefly what steps a personal traveler would have to do? They need to go to a consulate, I guess. They need to get an appointment. They need to then attend and then come in. How does that work? If you could just say quickly what that person might need to report to their HR and manager that they need to do in order to come back.
Well, so you're saying that so it depends on the circumstances. So did you say that they did not have a visa in their passport?
Yeah, they don't have a visa and they'd like to travel, and then they say, I'm going to take 2 weeks vacation. I'll see you in 2 weeks. Is that realistic? Or does HR
Probably not.
does HR need to prepare the manager for what this really means when they say that?
Right. So they will need to go on to the Department of website and see what the wait times actually are in the consular posts that they intend to go to. So, for example, some countries like India still have very long wait times. So they really need to look, because it can be while they're coming down, some consular posts, it could be like 6 months. So they're going to have to get themselves aware, and then their managers on board that it could be that long, and perhaps choose not to travel depending on where they come from. So really the bottom line is that they have to do their due diligence and see what the backlogs are in any of the consular posts that they can go to.
So even before agreeing, HR saying, yes, go take your leave, it may be something that you need to explore with everyone. What happens if someone is delayed a couple of weeks or a couple of months? Do we hold the job? What does our short-term leave policy tell us that we're allowed to do? How can the person work remotely in the interim? The second part of that would be for a business traveler. I think you and I have had some interesting experiences in trying to set reasonable start dates for people coming, to come to the U.S. Does this visa processing delay at the consulates affect them as well? Absolutely,
just as much. So, and again, it's the same thing. It's going to be pre-planning. It's going to be looking at the wait times at the consular posts. Well, first determining which consular posts are possible, because some may have shorter wait times than others, and then pre-planning so that the employee and the manager are aware of what they're actually in for.
Is there a way to shortcut that process in terms of, if you're looking at it, you go online and you look at it and you say, the processing time is 331 days. Are there expedites, or can you go online and try to check? How would you do that if you're trying to cut the time?
So you can request expedited treatment, but they are not granted particularly readily. You need to have a really good reason. So it usually requires a letter from your employer, that most likely an attorney prepared, explaining why you need expedited treatment, and then you submit that to the consular post and hope that they grant it. So, and I wouldn't say that the success rates have been enormous, because lots of people are in the same boat. A lot of people would like to come back to the United States and start or continue their job more quickly. But there are now some things that the Department of State is doing along these lines that may help the whole situation. So what they have been doing, they've started doing, is waiving the in-person interview requirement for certain visa categories. So they've waived it for students, for temporary workers integral to the supply chain. So for example, if you're a technician or a VP of operations, a crew member, there's a decent chance that you will not be required to go through the interview process at all. So that has been an enormous step forward that the Department of State has undertaken.
Mhm.
And now they are about to, I believe they're about to start a process where if you're, okay, they will grant interview waivers for non-immigrant applicants renewing their visas, assuming that the visas have not expired longer than 48 months ago, if that makes sense. Kathleen, were you about to ask something on that?
Yeah, and then so then it's possible if a waiver is granted, then they can just submit their paperwork online, or they can submit their paperwork by Federal Express. No need to travel outside the country, and they would get it. They would do a Dropbox, or I'm sorry, no, they would have to go, but they would do a Dropbox.
Right. That's
Okay.
That's correct. And they are so the Department of State is predicting that this process, they're estimating that it will save that 30% of the non-immigrant visa applications will be eligible for this interview waiver. And if that happens, it will speed up the whole process, because individuals who really need an interview will get those interviews much quicker. So this is very good news in terms of being able to move forward.
Also, I think they've made some more dispensations for students, so it's a little easier if someone is a teacher who's going to be coming in to teach classes, or a student who's supposed to report. There's some more fast tracking for them.
That's correct. Yeah, that they have been doing. It's relatively new, but they have been doing it, and that has helped to move things along.
Okay, great, thank you.
Yep. All right, if I could have the next slide. Okay. So this is going to bring us back to what both Neil and Kathleen spoke about in other contexts, and that's pre-planning. So the question is, what are the options for retaining an employee? So generally, if you want to retain an employee, you're looking at either extending their status or applying for a green card or lawful permanent residence for them. So, and as Kathleen had mentioned, frequently HR does not know who exactly is going to need these extensions, or they don't necessarily have the whole picture at their fingertips. So the first piece of advice is to work with either outside counsel or your immigration department to figure out how many employees are expiring. So, you know, get to know what is your workforce and what's the big picture, because the rules can be quite confusing. There's some rules that allow for automatic extensions, and then there are other rules where you have to affirmatively take an action to extend the status. So it's important to have a big picture of who's out there. And especially, go ahead.
I'm sorry, when you're talking about monitoring that workforce, again, maybe periodically taking a look as HR and management does their planning quarterly or semi-annually or year-end, which is an ideal time to do that, just to see how, in connection with people's performance reviews, whether they're foreign workers or U.S. workers, are they someone you'd like to retain? Are they someone you'd like to promote? Are they someone, so when you're looking in terms of timing there, and that ties in with the timing on if they are a foreign national, which is the next question, then, you need to look at the timing of retaining them, because they may be running out of time. If you're doing a good job monitoring and working with Immigration Counsel, you'll usually know 3 or 4 years in advance of what their end date is going to be. And then think in terms of the next thing, permanent residence, once the extension runs out, and just some of those categories, some of those possibilities for what you do. What are maybe some of those options that people look at?
Okay, so for lawful permanent residents, this is where planning ahead is particularly important. So as a rule of thumb that we use is that if you are intending to file for permanent residence, you want to sit with your managers and identify who those people are. Who is it that you wish to keep? And then have a 3-year plan of when you're going to start this permanent residence, and then speak to council about what type, because generally there's PERMs or labor certifications, which is a very lengthy process, or there's category 1 for the aliens of extraordinary ability. So for example, if you're an academic institution, outstanding researchers, or managers and executives, if you're a multinational company. But to have a plan, a big picture plan of who you're going to want, who you want to retain, and in what way you're going to proceed with the green card.
You know, the pre-planning on that, particularly, you alluded to the fact that a perm is a really long process and involved. Now, we'll take a second and just explain what the perm is. With the perm, this is a full-blown market test where the company is going to have to make applications before 2 agencies, Department of Labor and Immigration Service. And starting with the Department of Labor, they would need to provide to them a title, set of duties, education, and experience requirement, and ask the Department of Labor to come back with a prevailing wage determination. And that's the wage that they believe should be paid to someone performing the job on the terms and conditions that the employer described in that description. Once that comes back, the employer would have to compare that prevailing wage to the actual wage being paid. And if the two are consistent, engage in a market recruiting, and advertise and recruit in 6 required venues that require posting at the Sunday paper, 2 Sundays, 7 days apart, local paper, job search website attached to the paper, copy on the company website, copy with the unemployment office in the state, and a hard copy posting, and something with the job search website attached to the newspaper. That's designed to give a full-blown recruiting effort to show to the Department of Labor that you have tested the market and you've not found another minimally qualified worker for the job. That requires so much pre-planning because you have to first be sure that the wage is going to be consistent with the wage that you're paying, that the individual has a degree and level of experience that's consistent with the level of job that you're going to be employing them in. And once you start the process, it's generally not possible to change the job, to make promotions. The process itself for a non-backlogged individual is maybe 3 years, 3.5 years, which seems long, but it's great because when compared to backlog countries, India, Mexico, China, and the Philippines, nationals of those countries are looking at a 7 to 9 year wait to get through for the green card. So the company has to settle in and say, okay, this is a person I'd like to retain. I'm willing to wait 3.5 to 9 years of gainful employment with this individual, where they're going to be loyal and working with us. And we're able to promote them in terms of salary and professional development, but not necessarily in terms of the usual kinds of promotions that you would do with a U.S. worker. So that's one of those situations where you have to be thinking, okay, what is our plan? Victoria was talking about 3 years in advance, which is great. Where do we think this person's going to be in 3 years, in 6 years? And are we going to be able to move them through this system and get to the green card in a manner that makes sense? Are there going to be other workers available out there in the field? And in a lot of cases, if it's an administrative or technical job, there may be availability. And you know that when you apply for, when you advertise and recruit, you're going to find other minimally qualified workers. If that happens, that wouldn't be the right person to sponsor, or wouldn't be possible to do permanent residence. In that case, there may be other options. The person may have, let's say, a relative, an immediate relative, or a foreign assignment or things like that. So the perm is just ripe for, I guess, pre-planning. So I guess that kind of segues into the visa bulletin, Victoria. What are those processing times looking like?
Okay, so if I could have the next slide. So the December 2022 visa bulletin just came out, and it includes a variety of updates. One thing is that the estimated employment-based annual limit for FY 2023 is 197,000. And that is an improvement. In most, the general allotment is 140,000. So this is a larger number due to numbers that were not used during the pandemic.
Now, Victoria, when we say the employment-based annual limit of 197,000, that's all categories, all jobs in the United States each year. Only 197,000 people can get through on an employment-based case. It seems so small, right?
It is so small. Yeah, it's really outstrips the demand. Or the demand outstrips it by quite a bit.
Yeah.
And that's why there are backlogs applicable to certain countries, especially India and China, where a large number of foreign nationals are trying to immigrate. Okay, so in this December 2022 visa bulletin, the Department of State determined, because of the demand, that it needed to establish an employment-based second preference, what they call a final action cutoff, and a cutoff for what they call filing dates. And so, except for India and China, the final action date is November 1st, 2022. That's the priority date. And for the filing date cutoff, it's December 1st, 2022. And this makes more sense if you know that these two categories were current in November. So this is a back step. And this was due to earlier miscalculations or misestimations in the additional numbers that would be available to India for the employment-based second preference.
So Victoria, when you talk about priority date, or you mentioned priority date, what is that? That's the date of filing for a particular?
Yes, that is the date of filing. So if it's a perm case, for example, it's the date that you filed with the Department of Labor. If it's a national interest waiver, it's the date that you filed with USCIS.
And so for HR, when an individual employee will come and say, I'm worried about my priority date is my place in line, they're talking about trying to get to a certain level where they're in the shortest possible line based on their priorities. So HR may often hear from individuals that when you're talking about that permanent residence that we were talking about, that they'd like to be in a higher category. They want to be employment-based 2 or employment-based 3. Can you just mention the difference between employment-based 2 and 3? What do you need to get in there?
So employment-based 2, you need generally a master's degree or 5 years plus progressive experience. And EB3 is a bachelor's degree. And we do see cases fairly regularly in the academic world where or even some in other industries, where the individual will want EB1, because that is usually current across the board, so much quicker than other categories, but where they are not really eligible for EB1. And that's where it becomes managing the expectations and talking to the individual about what's realistic under the circumstances.
Yeah, and that's a real key in managing things for HR, because you will often have individuals saying, I want to be in this level to get a shorter line. I think I qualify. That's something where you can really partner well with Immigration Counsel to have a call and just go through it with the manager and the HR and look at what the criteria are. Because in this day and age of the internet, individuals go on the internet and say, well, I clearly qualify for this category. I'm a waiver, a national interest waiver and things because I have a master's. They're just easy. It's easy to make a mistake and think that they do qualify, or you'll be barraged in HR with requests for multiple filings. Individuals will ask you if they can file a perm and a waiver, if they can file a perm and an outstanding researcher, because they believe they'd like to try to get to the higher category. So the management and the pushing back, in the nicest possible way. It's always helpful if you have some backup from Immigration Counsel to work it through with you before you get the individual on the line. You understand now from what Victoria is saying, with only 197,000 across the nation per year, why people are so frantic to get through. That makes sense.
Yeah. So as far as this December 2022 visa bulletin goes, there is better news in the other categories. So for employment EB1, first preference, it remains current across the board, and that includes India and China. And in EB3, which again is the professional and skilled workers or workers with a bachelor's degree, for all countries of chargeability except India and China, it's current. And for India, it has actually advanced by 6 months. So the new priority date is June 1st, 2012. And for China, it has advanced by 6 weeks. So the new priority date is August 1st, 2018. So those are 2 areas of improvement.
Well, we've got
relatively speaking,
bit of light at the end of the tunnel. So Neil,
let me jump in and take us home here, given the timing. Can we project to the next slide? So on termination, just a couple of things from an HR standpoint. Just be aware that to effectuate a proper termination, particularly for the H-1Bs that we've been talking about, that requires notification both to the individual, notification to the government, and it requires the offer of return transportation for that individual. So you have to be aware of that. We also had some changes, particularly what's going on in the tech field right now with all of the massive layoffs. There was a change that took place back in 2017 that did grant an additional 60 days after the cessation of employment for individuals who are currently in the E1, E2, E3, H-1B, L, O, and TN status. So there is a little bit of a grace period for individuals that if they in fact are terminated, they have 60 days in which to potentially find new employment or to change their status before having to leave the country. The obligation for the return transportation cost still incurs if in fact that person is going to depart the US. The other thing to be aware of is severance. That has been a gray zone, not necessarily a gray zone, because since 2020, we have a memo from USCIS that does not recognize severance as extending that period of time. So we are waiting to see if we will ever get any clarification, but right now, the fact that an individual gets an additional period of time for severance, if they are off premises and no longer working, the government at least has taken the viewpoint that that is their termination date, and the 60 days starts from the date that they are no longer on premises working, as opposed to when their severance will expire. And then the last area we would just like to touch upon is your I-9 end-of-year audits, and that is really important. If we can move to the next slide. I-9s are one of the banes of existence for anyone involved with the I-9 process. Unfortunately, it is something that you do need to take caution on. For the last 2 years, we haven't seen a whole lot of I-9 movement. And then as we've come out of COVID in the last 2 or 3 months, all of a sudden, the I-9s have become active again. Any cases that were in abeyance are now active again. And we are expecting a large uptick in I-9 audits. What is an I-9? Well, obviously, any person that you employ, you have to complete an I-9 form for. And it is one of those 3-page forms which result in massive fines to a lot of employers who are getting it wrong. Basically, what the I-9 was is it shifted the burden from the government agencies finding people who are here illegally to employers verifying that the individuals that they hire are in fact authorized to work. And if you get it wrong, that is, if you have no foreign nationals and you fill out the form incorrectly, you're looking at anywhere from $230 up to $2,300 per violation. And if you in fact have an individual whose status has expired or is working without proper permission, you're looking at close to $600 all the way up to $4,600 per violation. So these add up quickly. And the average fine for many employers, small employers, is almost $100,000 in fines for getting the I-9s wrong. So you should at least have done at least one internal I-9 audit. And we certainly recommend that you have an external, because what's the problem that we see when we do an external audit? That is somebody else coming in from outside. The person who's making the mistake continues to make the same mistake. They don't recognize it's a mistake until somebody else is looking at it. So it is important, obviously, to have an end-of-year I-9 audit being done. The other thing you need to be aware of is IER. That is, normally I-9 audits are done by wage and hour, or ICE, to governmental agencies. There is a third agency, which is under the Department of Justice, which is very, very active, and that is the Immigrant and Individual and Employee Rights section under the Department of Justice. They're responsible for citizenship status discrimination. They're responsible for national origin discrimination and documentary practices errors and retaliation.
Neil, do you want to advance that slide to number 21?
If you advance a couple, we can just see some of the companies. Go to the next one, and the one after that, and the one after that, and the one after that. One more. Here are all companies that we know and love: United, Continental, American Express, Forever 21, UPS, FTD, Microsoft, Facebook, Sealed Air. What do they all have in common? Well, every one of them have faced a fine from IER for discriminatory practices relating to immigration, and they have either had a settlement or a fine imposed on them. The last two, Infosys and Asplin, were both I-9 violations. Infosys paid $34 million for their I-9 violations. Aspen paid $90 million. So we are talking about major things that affect the company's bottom line and affect your publicity. Let's go to the next slide. So the Immigrant and Employee Rights basically warns you not to discriminate against workers during the I-9 and E-Verify process. And we say, we never discriminate. But a lot of companies are getting it wrong. What are they getting wrong? Number one, you cannot request more or different documents that are required to establish the worker's identity. And you cannot tell individuals which documents they should be presenting to you. Those are big both no-nos, and they are very heavy fines. And you have to accept any document that is sufficient to complete the I-9. And again, the other area where a lot of companies are getting fined right now is re-verification of green cards. Green cards do not get re-verified. That's a biggie. And in addition to that, nor do identity documents. So if the driver's license, the List B document, is expiring, you do not re-verify an identity document. So let's just jump ahead to the next slide. You can see every month we get companies fined by the IER. And if we go to the next one, the ones that we've listed, number one is the most recent one that just came down was for Giant, the big supermarket chain. What did they do wrong? They determined that Giant had routinely required, again, specific documents from newly hired non-US citizens to prove they had permission to work. What were they doing? They were asking permanent residents who check off on the I-9, US citizen or permanent resident, they check off permanent resident. Giant said, we want to see your green card. Can't do that because they could just as easily have provided a driver's license and a non-restricted Social Security card and met the obligation. Next slide. PMM, a professional management organization. What did they do? Same thing. They asked lawful permanent residents to show their permanent resident card. What happened? Civil penalty, $300,000. And just like Giant, they're now going to be monitored for the next 3 years for their HR department. Not something you really want to do. Next one. Next slide. Here's a bunch of other well-known companies: CarMax, Capital One Bank, and Walmart. What did they do wrong? Well, they were recruiting on a college campus. And what did they say? They said, we're looking for qualified students who are US citizens or permanent residents. They excluded other individuals who are work authorized. CarMax, Capital One Bank, and Walmart ended up paying in excess of $300,000 in civil penalties because of the discriminatory advertisements that they posted. And they are part of what were 20 companies this year that have all been fined for the exact same thing, hiring discrimination. So it is important to do a training session of your recruiters as to what is permissible. Let's look at the flip side. Next slide. Here was a technology company, did the same thing. Basically, 3 times they excluded asylees, refugees, and US nationals when advertising vacancies for only US citizens and lawful permanent residents. Was a no-no. But they also did the opposite too. Not only did they indicate that they would only hire US citizens and permanent residents, they tried the other way. They said, we will hire H-1Bs. We are seeking H-1B visa holders. Well, unfortunately, that was also found to be discriminatory because that was against US workers and permanent residents who would qualify. And they ended up with a $12,000 penalty. So they got away a lot less expensive, but also subject to the 3-year monitoring period to ensure compliance. And our next one, here at home, for those of you who are here in New Jersey with us, Radstead also asked for specific documents. They got a $135,000 fine and back pay to the affected worker. Next slide. Now, Westpac, this was an interesting too, because Westpac, which is an agricultural company, this was one where they were trying to do the right thing. They were doing their I-9 audit. They saw that some of the green cards were expiring for their employees. They asked the individual to provide proof of continued work authorization. And of course, they got a civil penalty because you cannot re-verify the green card. So again, really training is appropriate for any person who is going to be involved in your I-9s and is involved in your recruiting. And the last one we'll show you is the School Board of Palm Beach County. This was again where they had asked for permanent resident cards. Here they got a $90,000 civil penalty, $100,000 in back pay, and again, subject to departmental reporting requirements and training. So last slide. So again, bottom line here is you can never request more or different documents than those required by law. That becomes document abuse. And while you may be tempted to require specific or multiple documents during the I-9, that's a big no-no. And even requesting or suggesting a specific document can be seen as screening your employees based on national origin or citizenship status, and that also should be avoided. So with that, that's a lot to cover. Hopefully, we've touched on a number of areas that you've already had on your checklist. So I'm going to now turn the program back over for some questions. I see we have a few that have come in, so let me run those past, try and see if I can there. Are there limits on H-1 visas awarded depending on the country? So one question came in is, are there limits on the H-1B visas awarded depending on the country the person is coming from? Kathleen, do you want to take that? Are there any limits on H-1 visas awarded on a specific country?
No, it is based on the lottery system. There are quotas. There are quotas for the master's cap, quotas for the bachelor's cap, and it's a first in, first out. It has nothing to do either with the type of job. So they're not higher level jobs that would have more priority. But if you do have a master's, the master's, if you're not selected in the first 20,000 for the master's, you'll drop down to the bachelor's. So you do have a slightly better chance if you apply for the master's than you do bachelor's, but no per country limitation on that.
What are some concerns to look for in potentially hiring H-1Bs? I see.
Concerns on potentially hiring H-1Bs, it's always an issue. Navigating the lottery and the deadlines, being prepared. So making sure that you assess who you'd like to register for, because registration, if missed on March the 1st through the 18th, that's it until the following year. The understanding that there are only 85,000 visas, and the selection of, last year there were 485,000 people applied for 85,000 visas. So the selection rate is below 50%. So you may have to do this more than once. The wage requirements, remember that prevailing wage. Department of Labor will set the wage that they believe is appropriate for someone performing the job as you've described it. And that wage may be higher than what your company is prepared to pay. Complying with specialty occupation guidelines. The H is available for someone with a bachelor's degree, but the bachelor's degree has to relate to the job duties performed, and that it has to fit within the education and experience requirement and the regulatory requirements to be eligible for that category.
On one of the questions that we just answered, which was, are there any limits depending on the country? I would clarify that in that there are some countries that are exempt under the H-1B program. So if we're dealing with an Australian, Singapore, Chilean, those individuals have separate quotas that have not been reached in any of the previous years. So while individuals may be subject to cap, if you are in fact recruiting someone from Australia, from Singapore, or from Chile, they do fall under a different H-1B classification, and they have not been subject to the caps and quotas, because those caps and quotas for those nationals have not yet been reached. There was one on work authorization.
The TN, Canadian and Mexican do not have to go through the H cap. They have the possibility, if they qualify and are eligible, they can apply for a TN.
Yes, TN is a good alternative also for Canada and Mexico nationals, but you have to be careful in that the individual has to meet one of the occupations that are listed under the North American Free Trade, which has now been changed to the MLE, because not every classification or profession will qualify for those. We have a question: what process should be followed when work authorization is expiring? I guess that's pretty broad because it really depends on what the work authorization is. Work authorization has some 30 different categories that someone could have work authorization under. I guess the key from our standpoint, from a legal standpoint, is you want to make sure that you are tracking expiration dates for work authorization. You want to be ahead of those by 6 to 7 months. Some of those would be the employer recommending or seeking the extension of the work authorization for the individual. Others may be doing that on their own independence, such as TPS, DACA individuals, deferred action. There's any number of categories for work authorization. So the process really is identification. Hopefully, if you're working with legal counsel, they are already tracking these individuals, or if you as HR are tracking F1 expirations, tracking TPS, DACA, you would be wanting to notify the individual as you're doing your I-9 updates that they're going to have to provide additional documentation or an action is going to have to
Neil,
take.
I think on that one too, on work authorization is expiring, if it's extendable, then identifying and make sure that you get the extension process going in enough time to file. You can file as late as 1 day before the expiration, and you'll keep the process going and keep the person in status. But if work authorization is expiring completely, that you're not going to sponsor for permanent residence, and there's no further extension, then the process becomes almost an I-9 process. You're not able to extend the person any further. You're not willing to sponsor, and no employer is ever required to. but then that would be a situation of an I-9. We cannot employ the person without work authorization because of I-9. It has nothing to do with immigration, but it's a situation where it's not effectively a termination, but the individual is no longer work authorized and they cannot be employed. So if that's a question of a terminal expiration, that's what your process would be. If it's an extendable, then you would look at doing the extension, and that can be done as late as 1 day before the expiry. I hope that helps.
Yeah, I see a premium processing question. Must you file the premium processing fee with the underlying petition, or can it be paid after filing?
Yeah, it can be paid after. So that's not an unusual set of circumstances, that you might file and hope that the government moves quickly, and then it turns out that it doesn't, or perhaps your needs as an employer change and you need a person to start sooner. Then you can upgrade to premium processing, and it's really a relatively simple matter of putting in a form and sending them a check.
And I see. Wait, can you confirm if the foreign national can pay the premium processing fee?
Yes, but with a caveat, and that's that employees, that if an employee pays, it shouldn't. What you're trying to avoid is a drop in the salary relative to what the Department of Labor said was the prevailing wage. So if the employee pays, or if the employer pays, and then that drops the person's salary, that's not allowed.
So in an I-140, generally that can be paid by an individual, but in the H-1B content, you'd have to be very careful. Normally, the H-1B is a fee that has to be paid traditionally by the employer. If it's part of the employer's benefit to get the person on sooner, then it probably would not pass muster and should be paid by the employer. And if it's going to drop the individual's wage below the prevailing rate of pay, that's going to be a no-no. The individual wouldn't be able to pay it in that scenario. So I think those are two areas to be concerned with. Are there any classifications that allow dependents to work? Maybe.
Yeah, there are a couple actually. The H4 spouse, it can work. If an individual is married to an H1B holder, again, these H1s that we've been talking about, if you're sponsoring the H1B for permanent residence and you've gotten to the I-140 stage, that's a perm approval, and you're filing the second stage, then you would, if that second stage is approved, then the dependent spouse can apply for separate work authorization based on the husband or wife's approved H1 status and approved I-140. That would result in an EAD card similar to what the students have. Also, E-holders. The E2 spouse can also be work authorized, but now it's a little different. The E2 and the L2 spouse used to have to apply for a separate work authorization. Now, by virtue of their status itself, they are going to be able to work. The designation when they enter is an S after their classification for spouse. That allows them to work automatically without the separate application. It also allows them to get a Social Security card.
I see another one that, again, is a little bit broad as a question. Do these rules apply to a graduate student participating in a fellowship on a visa? I think the answer are yes, the rules, if we're talking about change in job title and location, particularly if we're dealing with a STEM student, because if we're dealing with a STEM on their 2-year, there is an obligation on the form to notify any changes in the underlying employment that has been agreed to. So I guess, does anybody else have a different feeling on that? That's how I would respond, is that that has to go back to the foreign student advisor if there is a material change.
Is that where you would send it, Victoria?
Yeah, and I think the question might relate to some new changes in labor law having to do with graduate students, but I can't tell. But that wouldn't change what the immigration law is relative to that group.
And the last question I see, and we're probably doing well on time, is what are the benefits of an external I-9 audit But I guess the answer is that the external I-9 audit, number one, you really discover a lot of correctable errors, which could be quite costly if done during either a wage and hour or a ICE audit. There's a lot of things that we can correct, and those correctable errors also allow us to minimize the liability by reducing the number of problem I-9s, which is part of the matrix that ICE uses when they determine what their fine is going to be. And it also goes towards good faith that you have already engaged in a review and cleaned up any of the applications that could be cleaned up, and the ones that are technical or substantive, the ones that can't be corrected, at least it goes to good faith, and it could potentially reduce a fine by up to 5%. It also is a lot easier on an employer. If you're in the middle of an investigation, you only have 3 days technically in which to provide those I-9s. Whereas if we're doing an external audit, we're not under a time pressure. Basically, we can do it over a period of time that works for a potential employer to work within their schedule and their HR department's schedule. And again, it also allows us to identify errors that are being made in the training so that we can go back in and do those corrections into the training for both managers and our HR personnel. So
Neil, you have a really good I-9 training. It's interactive. You put up examples and things, and so it's certainly worth a consideration. We can do those remotely. We can do it by Zoom and get the whole group in HR involved who would have anything to do with the I-9, and it helps to reinforce that training. As Neil had pointed out, the person who makes a mistake tends to make the same mistakes over and over. It's not their fault. It's just that it happens. It's human nature. I look myself when I do I-9s for employees, I look at the I-9 instructions every single time I do it, and I still scratch my head and have somebody else look at it before.
Yeah, and I guess the bottom line is if you are involved with I-9s, you have to have the I-9 handbook printed out and available to you. And if you happen to be doing E-Verify, then you get to add another 200 pages of light reading as part of your training. Because again, making mistakes in this area could be costly both to the company and certainly to you from an HR standpoint. With that, I would like to thank all of our participants, Victoria, Kathleen, and NJBIA, for giving us an opportunity to talk to so many of you with regard to an area of law that is near and dear to our heart. So we thank you all, and we wish you all the best for a happy and healthy holidays. Thank you.
And thank you to Neil, Kathleen, and Victoria again. And just wanted to remind everybody that you'll be receiving a recording of today's presentation and the PowerPoint via email. Thanks again for joining us. This is Alice Skens for NJBIA, and great to see you all, and have a wonderful holiday.
Thank you.
Thank you.